Hey, good morning, everybody. This is the second panel. Okay, moving on. I'd like to begin by thanking Dean Hampton for hosting this and for her very helpful interjections from time to time, as she is, after all, the dean, and she's had a lot of experience in taking on. Also, of course, to Canute for making all this happen, and very much to the panelists on the prior panel, Skip and Kathy here in the room, and Bob so memorably with his furry friend on the video. So I'll set the stage and provide some background for the panel's discussion overall. My two academic colleagues, Arthur Levy from Rutgers Law School and Mercer from the University of Mississippi School of Law, are on the phone and will be participating. Both of them, needless to say, are renowned scholars in this field. So specifically, our panel will focus on whether the SEC's proposals undermine the statutory framework created by Congress in the 1930s through the 1940s. I myself think of this as kind of the foundation era for the large structures of securities regulation in the United States, uh, creating, as we saw, in the last panel, separate regimes for regulating two types of activities. And at least some of us understand those two activities to be distinct or different and have some important differences. So these would be, first, the distribution and sale of securities by issuers, say typically corporations, and their agents, that is to say brokers. This is a very important and very distinct regulatory world with a lot of its own nuance and specifics. It includes the world of investment bankers who underwrite initial public offerings, committing to attempt to sell securities into public markets. It encompasses, as we saw in the last panel, brokerage or agency functions. It encompasses the stock exchanges and the regulation of the exchanges as such. So that realm. Uh, the second realm, of course, then is the furnishing of advice to investors by persons who are hired or engaged to furnish advice. This is a different regulatory realm in many ways. It's a realm of one on one advisor investor relationships. It also encompasses the management of others' investment assets. Okay, would be defined to be investment advisors in the United States. But as our panel will discuss, underlying changes, this was mentioned in the first panel as well, I think most by Bob, or most strongly by Bob, underlying changes in the world have made asset management activities and advising activities more substantial and economically more substantial as reliable sources of business income for financial firms. This is largely, I think, due to technological innovation that has dramatically reduced uh, the cost of executing and carrying out agency functions or executing or simply execution functions in transactions. Now, maybe unsurprisingly, we're presently in a context in which there are many regulatory questions for the SEC. Uh, how adequately the SEC grapples with them, of course, is a separate question. So, what do these include? Well, one point discussed, or one issue discussed in the last panel, is interestingly simply the use of language, right? I mean, the use, in particular, the use of the advisor label. okay, and advising. It struck me when I read through the SEC's best interest proposal, all 400 and some pages of it, that the commission is not entirely consistent. Sometimes what it is that brokers provide, specifically to clients, is referred to as a recommendation to to purchase or sell a particular security. Other times, though, they lapse into advice, into referring to the giving of advice as opposed to simply the providing of a recommendation, which is, as I understand it, the regulatory term applicable to what brokers do internal to the stock brokerage regulation. A second big regulatory issue, which the SEC's best interest proposal highlights, and I think is indicative of concern on the part of the commission, is regulation of conduct, on the ground conduct. Clearly, some things are seen by the SEC as deeply problematic. These would include sales contests, better to incentivize brokers to sell particular products. Whatever the commission's overall take intellectually on conflicts of interest, the proposal seemed to single out certain types of incentives that might be provided to brokers as deeply problematic, and I might say antithetical to professionalization and basic understandings of what it is to do something as a profession. The third point is professionalization, which was, I think, a deep theme in the first panel and its implication, but also then the relationship between professionalization, a profession's own definition and understanding of itself, and the significance of that relative to formal regulation. And I was hearing maybe different things out of the first panel about the relationship between the two. So I move on to the final point I want to make, just to frame the further discussion we're going to have. Very important, of course, that regulation in this area be very thoughtful about conflicts of interest. I think myself, it can fairly be said about the SEC's proposal that much is made of the fact that some conflict is endemic or intrinsic to any relationship in which one person does something on behalf of another person. Okay, that's Patty's example of the advice vis-a-vis paying off the mortgage. Right, I do not remember that as an explicit example in the SEC's proposal, but it perhaps lurks in the background. But at least we who are lawyers and you who are entering this profession know there are conflicts and then there are conflicts. Okay, I mean, for investment advisors, as you know, for registered advisors, some kinds of conflicts are simply, well, illegal. Okay, so yeah, sure. I mean, we are all sinners. I mean, we all live in a gray world, but that's not to say that there are not degrees of gradation as possible. And one way to think about that, obviously, is the fiduciary standard. Then, oftentimes serves as a very useful constraint. I mean, regulation can say from the get-go that some conflicts are simply unacceptable and should not be permitted. Acting as a fiduciary means that there are then further constraints imposed or other constraints imposed on acting with a conflict or how the conflict is handled. The SEC's proposal also strikes me as not fully accepting of or on board with what's a very basic proposition in, I would just say, the general law, which is where I mostly come from, which is that there's a big difference between, we might say here, consenting to a conflict in a kind of upfront generalized awareness as opposed to transaction by transaction consent with all the specifics. This is a very basic concept in, for example, the law of trusts, this distinction. A very basic distinction in the law of agency itself. Okay, so that consent, transaction by transaction, fully informed consent is very different in how the general law treats it from a kind of upfront, one-time, generalized disclosure. And we might ask, well, disclosure of what? Okay, and it didn't seem to me that the SEC's proposal along those lines was asking for very much. But I conclude my general opening observations with a few words from Professor Frankel, for whom this award is named and the prize is named. So this is from a very recent paper by Professor Frankel that came to my attention just a couple of weeks ago. Here's what she wrote, or part of what she wrote. She wrote, a subtle way of undermining fiduciary law is to make the law more opaque and less clear. Fiduciary law began and successfully introduced the description of fiduciary duty as a duty to act in the best interests of the client. This expression was adopted by supporters of fiduciary law because the expression sounds benevolent. And it's true. After all, fiduciary law is designed for the benefit or interests of the clients. But she goes on. However, what does best interest mean? Okay, and as we saw in the first panel, the SEC's proposal doesn't define that. Is it a clear legal expression, Professor Frankel asks? Combines the duty of care with the duty of loyalty. Best interest covers the main problem of fiduciary law, conflicting interests of those in power. But she asks, and here I know her and I can kind of visualize her saying this, is it ever good for me if someone gives me advice that is paid by someone who has different or conflicting interests for that advice? The best interest may then enter an unclear area or issue of whether the fiduciary's conflicting interests may be in the client's best interest. She concludes on this point, your guess is as good as mine, but both of us are clearly and unequivocally guessing and perhaps confused. So with that preface, let's hear first, or turn first to Professor Arthur Levy.
Thanks, Deborah. Can you hear me?
Yes, we can hear you. Now, I'm here in the room and you're not, but I'm looking out at an alert, attentive audience.
Terrific. Well, I'll try to speak up. If you have any trouble hearing me, please let me know. So first, thanks, Deborah, for those introductory remarks. Wonderful as always. Thanks to Knut for the introduction, the invitation for me to give a few remarks, and I promise to keep them short as we discussed. And perhaps most importantly, congratulations to Harold on receiving the 2018 Frankel Fiduciary Prize Award. It's really a wonderful honor, and so congratulations and all the best. So in preparing for this session, Knut asked us to address, as Deborah indicated, to address the question of whether the SEC's proposals undermine the statutory framework created by Congress, which, as we know, established separate regimes for regulating the distribution of securities on the one hand and the provision of advice on the other. So when I first read that question, it sounded innocuous enough, but when I read it over a couple of times, I really had to pause. And I think that based on the way the question is phrased, I think my initial answer to the question is no. There may be things not to like in these proposals, but I do not think that they undermine the statutory framework, in part because the question, I think, is not properly posed. And let me explain what I mean by that. So the question assumes that there is one set of rules for distribution and sales and another set of rules for advice, and that broker-dealers engaged in distribution and sales while advisors provided advice. But of course, we know that's not the case, and that's part of the reason why we're here today. Broker-dealers always provided investment advice long before the Advisors Act was passed, and that's the reason why the proposals are before us. In a 2005 release for a predecessor rule, the SEC explained they actually did some good historical work in that 2005 release, and explained that until the time of World War I, brokers gave advice as part of their brokerage activities. And then around 1920, some brokers began to give advice for a fee, and sometimes through a special department. Well, in 1940, when the Advisors Act was passed, brokers who, as I say, since before World War I had been giving advice, they escaped Advisors Act regulation insofar as their advice was solely incidental to brokerage. Then, of course, over the years, the SEC interpreted the phrase solely incidental quite broadly. So that's the broker side. By contrast, advisors all along constituted a separate group of professionals who did not engage in brokerage and only provided advice. So the notion that there was a separate regime for distribution and sales on the one hand and advice on the other is really incomplete, because brokers always gave advice, but Congress did not see fit to regulate brokers under the Advisors Act. That was their wise decision, like it or not, in 1940. Brokers had their own system of regulation. So here's the point. It's not that the new proposals undermine the statutory framework. Rather, if anybody, I think it's the SEC that undermined the statutory framework by the broad reading of the phrase solely incidental over the years. So as we know, brokers not only marketed themselves as financial advisors, they trumpeted advice as the essential service they provide for investors. And it sounds like there was a good discussion of that in the last panel. I'm sorry I missed it, and I'll look forward to listening to it or watching the recording. And still, notwithstanding this development, the SEC did not rule that brokers' advice could no longer be considered solely incidental to brokerage. So as a result, brokers were allowed to transform effectively into investment advisors akin to advisors regulated under the Advisors Act, but they could avoid regulation under the Act. For that reason, the statutory framework was undermined, as opposed to the new proposals undermining the framework. So I think the current commissioners inherited a tough situation. They chose to deal with it in the proposal by effectively maintaining the statutory framework as opposed to undermining it, and placing a best interest duty on brokers that give advice without placing a fiduciary duty on brokers identical to the fiduciary duty under the Advisors Act. And we can talk about exactly what that means, and I have some comments that if we have a chance, we might take that up in the later discussion. So I'm not sure how effective the proposals ultimately will be, and I know there's been a lot of criticism that they don't go far enough. I heard some of that at the tail end of the last panel, but I don't think it's fair to say that they undermine the statutory framework Congress created. One more quick thing. I think you have to read the best interest proposal together with the prohibition on a broker using the title advisor in some cases. Again, I see that move as an attempt to preserve the two regulatory frameworks, one for brokers and one for advisors, as opposed to an attempt to undermine the statutory framework. So why don't I leave it at that, and more than happy to, as I say, take up a fuller discussion if we have time.
Thank you, Arthur. let's hear from Mercer and then get some reactions from our audience and other colleagues in the room.
Great, Deborah. Just want to make sure you can hear me too.
Yes, you can.
Okay. Thanks for your introduction, and thank you, Arthur, for that great introduction. I think we can set out a nice baseline for an interesting discussion going forward. And thank you, Canute, for including me on the committee and inviting me to join this panel. And I particularly want to thank Harold. I wanted to extend a more personal thanks to Harold. He may recall about 18 years ago when I was just starting my advocacy group, Fund Democracy, in my basement, just having left the SEC, completely unknown. There was a banner in the basement that said Fund Democracy because my 8-year-old daughter didn't put the D in fund, which was inspirational. And I was calling around to put together a panel on a mutual fund disclosure initiative that I had started. And Harold, as the investor advocate that he's always been, eagerly responded yes, and was a key in getting also Paul Roy to join that panel. And that's one of my sort of favorite memories going back over time. So Harold, I don't know if you remember that, but that was an important moment in sort of developing that part of my career. And I wanted to thank you for that. And it's also a sign of what a great investor friend you've been over the years.
Mercer,
so
report that
yep.
Harold nodded.
Good. And I'm also glad we have an alert audience. I'm sure Deborah and Arthur and I, we always have a completely alert audience in our classes. So that's nothing new. And Arthur, you really set up an interesting kind of parallel that I wanted to make to the kind of historical evolution that you started on with respect to the Advisors Act and the development of a broker's role, because there's a similar evolution that I think went on in the retirement side of regulation. And it actually may shed some light, particularly for our students, on just the nature of the way regulatory entities operate. So just to put the Investor Advisors Act issue in perspective, we know that in the 1930s and 1940s, brokers were essentially in the business of recommending a stock, and that was very much the philosophy of investment at that time. Harry Markowitz, who essentially invented modern portfolio theory, for which he won a Nobel Prize, hadn't published his paper on portfolio theory until 1952. So it's probably hard for many in our audience to imagine diversification not being on the tip of your tongue when it comes to personal investing, but that was not really even a developed concept at that time. And even Jack Bogle, who seems as if he has been here since the dinosaur age, was then only in 9th grade. Although knowing Jack, he was probably already outlining what would become his Princeton thesis on the economic role of an investment company. And you probably all know he went on to become the founder of Vanguard. But even Jack, of course, started out as an active fund manager at Wellington, and that at the time was still the way investing was viewed. So capital appreciation was a function of really picking the best stock. If you wanted income, you bought bonds. Individual investor characteristics, on the other hand, the idea of taking into account your particular risk characteristics was not really paramount. And even the early, what was called the shingle theory for broker liability, that was really focused on the broker having a basis for recommending a particular security. And it was then a far cry from what's really the current version of the shingle rule, which is known as the suitability rule. That's a rule that has been adopted by FINRA, which is the regulator for brokers. And it focuses on a litany of characteristics of the individual investor. So it also reflects kind of the evolution of the law over time. The issues we're talking about today are partly that sometimes the law does not evolve as business evolves. So let's now turn to 1974. And that was the year that the Employee Retirement Income Security Act, or ERISA, was enacted. And that was also the same year that Bogle started Vanguard. So we're still really in the pre-index fund era. Like the securities laws, the act was a product of the times. There had been a couple of decades of pension plans blowing up a lot of hearings that over time eventually became ERISA, which was really designed to address the root causes of those pension plan blowups, which in those situations would leave retirees in their 60s living essentially only on Social Security to fall back on. So we know, I think, that the defined pension plan of that era slowly gave way to what are known as defined contribution plans, the best known of which is the 401k plan. But the kind of retirement security part of ERISA was never really updated to provide income security in any sense for defined contribution plans. A good example of that is that ERISA requires pension plans invest no more than 10% of their assets in a single investment, whereas for defined contribution plans, individual employees are permitted to invest 100% of their assets in stock of the employer, which is ironic given that you would think the institution, the entity of the employer, would be better able to look out for its interests than the employee, but it's the employer who is limited to the 10% limit on one investment and the employee has none. So in the defined contribution context, though, at least the employers were subject to a standard that required the prudent management of those assets, and they had expressed substantive fiduciary duties in that respect. And they also had what are called prohibited transaction limits. So that's kind of an important distinction in ERISA because there are two types of regulation that really constrain the conflicts of interest that Deborah and Arthur have referred to. And those are really separately that substantive fiduciary duty and the prohibited transactions, which restricts transactions depending on your relationship with the plan, the defined contribution plan. And Harold himself has actually commented on this issue, for example, of allowing overconcentration, for example, in employer stock. I found a Wall Street Journal of 20 years ago, Harold, saying where you were saying the risk is enormous. The risk of having all your eggs in one basket overwhelms the value of any tax benefit provided. So Harold's been on this issue as well as many others. So we have the basic fiduciary duties and actually some minimum diversification requirements that apply to defined contribution plans like 401ks. And those have long since outgrown defined pension plan, defined benefit plans. Those are the company pension plans, and that happened back in the 90s. But as the world turned, a new product appeared on the horizon. That is individual and retirement accounts. And along with them, we've seen the development of a litany of types of IRAs. We've seen deductible, non-deductible, SEP IRAs, conduit IRAs, simple Roth IRAs. But the most important descriptors for our purposes are the self-directed and the rollover aspect of IRAs. So a rollover IRA is one that, as the name suggests, is made up of assets rolled over from a defined contribution plan, such as a 401k plan. And due to those rollovers, primarily, the assets in those IRAs now exceed, and have for a couple of years now exceeded, the funds in 401ks and other defined contribution plans. So just as defined contribution plans essentially have replaced company pension plans, IRAs are not on the way to replacing 401ks, but they will continue to outgrow 401ks, partly because as Americans change jobs more often, they're leaving the plan, the employer plan they were in, they roll over in an IRA, so it's inevitable that IRAs will continue to grow. The other key term, the self-directed aspect, means that the investors are actually doing the direction, not the employer. And that is not subject to whoever is offering the investments being held to a fiduciary duty or the best interest standard for purposes of ERISA. So the combination of this self-directed aspect and the rollovers essentially had the effect of moving what had previously been assets that are subject to the substantive fiduciary duty under ERISA outside of that umbrella. But of course, that had already happened to some extent in that there were fewer protections for defined contribution plans when assets moved there away from those company pension plans. So ERISA over time is originally designed to enhance retirement security, has really seen a pretty consistent cutting back of protection of retirement security. So this really sort of brings us now to the stage being set for how to handle what was essentially what scholars like to call a path-dependent problem, which is that you follow this historical path that leads you to a result that doesn't match up to what you might have created as a statute in the modern era. And at this point, the limitation on regulating IRAs was really a function of they were only prohibited transaction rules, and not the fiduciary duty standard. And the reason that those were not very limiting was that the prohibited transaction rules for fiduciaries were restrictive, but not for non-fiduciaries. So the DOL was faced with this issue of, if they're not fiduciaries, how do we bring IRA assets under that fiduciary umbrella? So they had a 5-part test for what was a fiduciary. It required that you provide the advice on a regular basis, and that it be individualized, and it'd be a primary basis for the customer's decision. So brokers, similar to the kind of solely incidental interpretation the SEC applied, which it deemed not to cover these kind of one-off transactions where a commission was paid. Similarly, the DOL's 5-part test also didn't extend the fiduciary definition coverage to those who did a one-off commission-based transaction. But the DOL, unlike the SEC, and this may be a function partly of the DOL being essentially an entity that has a secretary that is a part of the executive branch and operates pursuant to more maybe political direction than the SEC being a commission, which may be less flexible in doing the kind of about face that would have been required, as Arthur explained, in revisiting what solely incidental really should mean. So the DOL looked at these 2 parts of the 5-part test for a fiduciary, and they eliminated through rulemaking the regular basis requirement and the primary basis requirement. And that, of course, touched off a storm of opposition from the industry. But what I think is interesting here is that there's some significant parallels with the situation confronted by both agencies. In the SEC's case, what is the real statutory meaning of solely incidental? In the DOL's case, what is the real meaning of fiduciary? Each was confronted with a decades-old position that was anachronistic, but nonetheless, changing it required that they really do some heavy political lifting. And the SEC, as everyone knows, is a 5-person commission, and the Department of Labor is run by the Secretary of Labor, reports directly to the President. And this is particularly apropos in light of the debate about the Consumer Financial Protection Bureau, which is currently run by 1 person, and that some would prefer be run by a 5-person commission. So I thought that all might put kind of an interesting perspective on this issue of whether the SEC is acting consistent with the statute, and maybe we can look at it as a way that different agencies deal with that problem of statutes perhaps inevitably becoming anachronisms over a number of decades. So those are my thoughts for now, and I hope we have a great discussion.
Any questions from the room? Okay, I'd like to ask a question of both Arthur and Mercer, as I think comments from both of you are excellent. And as Mercer, I think, showed us, there's some very intriguing parallels between, we might say here, the predicament, the predicaments of the SEC and the Department of Labor. So, I mean, so the audience would know from the biographical information provided that both of you had significant tours of duty within the SEC, and have been obviously significant scholars of the Commission and its history over the years, as well as those regulatory specifics. Do you think, Arthur, or do you think, Mercer, that the SEC should be candid about its own role in creating the history that leads to the predicament in which it now finds itself? Now, Mercer is implying that institutionally, that's easier to do for an executive branch agency like the Department of Labor, which has, of course, its own risks, right, and challenges. But to what extent should an agency, like either here the DOL or the SEC, be straightforward and candid about its own role uh, in the history that creates the present dilemma that the agency needs to deal with?
So I can start, or Mercer, you're welcome to if you'd like. But I think from the SEC's perspective, at least one way to look at this is, I mean, sure, it's easy to say that the commission should be candid and come forward. I mean, I think in the case of what happened in the securities area, you know, it's easy now to look back and say, oh, well, the commission clearly erred at some point in time when it continued to define solely incidental so broadly, and look at advisors today. They look at brokers today. They have such a strong emphasis on giving advice, and as I've written many times, that's sort of the main course that they serve up to investors. It's not really, we don't think of execution anymore as a critical service provided by brokers. Advice is the name of the game, and as I say, it sounds like you talked about that on the last panel. But that was a very slow and gradual process over many years. Technology changes, but it changes slowly. Advice became more important, and I would say that the execution function became less important. Similarly, the other part of this is the special compensation part of the statute. So to the extent that brokers charge special compensation for advice, they cannot be subject to the exclusion that I spoke about earlier. Well, that was also a change over time, because brokers were actually encouraged to step away from charging commissions and to also begin charging asset-based fees. Some of those brokers decided to do that as a result of the Tully report, which came from the SEC itself. So these are very gradual changes over decades. And I know that we can now look back and say, well, they must have erred at some point. It's sort of difficult to pinpoint when that occurred. So as a result, I think that the commission could simply indicate that, well, as a result of changes over time, that their position has become, sort of for lack of a better word, outmoded or outdated, and they just have to now go back and sort of rethink some earlier interpretations. But the problem is the commission never wants to lock itself in. And you're always going to have commissioners, and in particular, you know, staff, who will say we have to be careful when we are sort of very clear about mistakes that we made in the past, because, you know, one never knows when we might want to return to those positions in some other guise. And so I do think there's sort of institutional challenges for the commission to step up and say, look, we made a mistake, or there was some point when we should have declared this to be inconsistent with the statute and we didn't do it. And so instead, I think you've got, you know, what you have now, which is a series of rule proposals that don't really indicate that the SEC misstepped in not sort of keeping up with the times. It just sort of indicates that times have changed and brokers perform these functions, and that they ought to be held to a best interest standard. And so here we are, we're doing it, because there's too many institutional pressures, I think, to come forward and be more transparent.
Okay. Mercer, reaction from you? I mean, would you say that from your study of the regulation of under ERISA, that the Department of Labor likewise never wants to lock itself in?
I think that the departments generally don't feel constrained in terms of being locked in by precedent, if you will, and that there's no doubt in my mind that agencies, as we're currently certainly seeing today, are quite willing to do an about face. So the idea of precedent and being constrained by past departments, I don't think operates on certain types of commercial regulation. I started my career actually in the defense world, whereas it's a very different thing in the Defense Department as to the role of precedent as well as in the Department of State. So it may depend a little bit on what you're trying to regulate. But I think that the point about that Arthur was making about you don't really know when something sort of is past the tipping point. It's kind of like I think it's like Achilles' ship. The question is if you remove a piece from his ship, or maybe it's Ulysses or Agamemnon's or somebody's, but at what point does it no longer become his ship? And that's kind of the question of when did the solely incidental interpretation no longer match reality? And I agree that there's on the other side of the agency question, built-in institutional constraints on the SEC. And to illustrate, each of the last chairmen appointed under Democrats made noises about how they were going to propose and adopt a fiduciary rule. They had a majority of commissioners every one of those years, and none was even able to get to the point of proposing it. So this is, clearly you could say this is not a political issue, which may lend itself to an institutional explanation. On the other hand, I note that the commissioner, the chairman in the 1990s, Arthur Levitt, was able to put out a proposal and get it adopted that took the opposite approach, which was to say, we are going to ignore the special compensation exception, which for our audience is the exception that says that even if your advice is solely incidental, you can't receive special compensation. And it was deemed to be special compensation when you were paid an asset-based fee like an investment advisor. So they adopted a rule that said even if you get special compensation, you won't be regulated as an advisor. That completely overthrew decades of precedent and the approach previously taken. It was due to the leadership of one person who really wanted to shake up the way things were operating in the business and eliminate conflicts of interest. And there's a lot to be said for when one or two people get a kind of bee in their bonnet. They can make things happen, notwithstanding institutional constraints. And you could certainly point to Phyllis Borsey at DOL and a couple of other people actually there who I think just made individual decisions. We are going to buck the system and go whole hog on this. And I think that the Secretary of Labor under whom they operated was not going into that thinking, oh, I'm totally on board with this ship. He probably had to be convinced. So you can buck that institutional trend sometimes if you have a particular personality who is able to take the reins.
So, Deborah, may I jump in for 1 second?
Yes, of course.
So Mercer makes an excellent point, and I agree with everything he said. I think the one point, though, to keep in mind is that in the example that Mercer gave, and it's a great example, but that rule, which was adopted and then not permitted to move forward by the courts, it was vacated by the courts. That rule, yes, it was a change in position, but the rule was permissive in nature. So it was allowing brokers to effectively charge what had previously been considered special compensation, but then essentially exempt them or exclude them through a permissive rule from application of the Advisors Act. And in that context, I think it's a little bit easier just politically to make that move, which is a shift from the past when you're essentially doing something that's more permissive. I think it's the opposite that's much harder, right? If we were to now if the commission were to take a different view on special compensation, the idea that I was suggesting is that would be a crackdown on the broker-dealer firms. That wouldn't be permissive, it would be restrictive. And so I think when you're going the other direction, it's a lot more difficult. I will just add one more quick footnote to this, and that is I do think, Deborah, on certain sort of tertiary issues, maybe not the key issues of the rulemaking, the SEC has, even in this most recent rulemaking, they haven't been crystal clear about it, but they have indicated that they might have to break from the past. So if you recall, one of the very interesting and sort of tough issues that's addressed by the best interest release is what to do with discretionary brokerage accounts, right? So this has been a difficult issue for many years. Discretionary brokerage accounts are accounts for the audience where, as you probably know, the broker gets essentially a power of attorney and can trade without checking in, with the customer or the client first, as opposed to getting approval for each and every transaction. Well, the courts generally held that brokers that ran discretionary accounts, even though brokers typically were not fiduciaries, in those sorts of accounts, they were considered fiduciaries. And in an SEC release, which was vacated by the courts, the SEC took a position that discretion would mean that broker had to be treated as an advisor. But that release, that rule was vacated by the courts. It was unclear what was going to happen to that interpretation. So in this most recent best interest release, the SEC takes this up again. And, they indicate, the release says that, look, broker-dealers with discretion in some respects have been found to be fiduciaries under state law, but it also says that the commission at times has recognized that some exercise of discretion can be considered solely incidental. This new interpretation, depending on what they do, would indicate that kind of discretion could not be considered solely incidental. And that would be, I think, a shift from a previous interpretation, and it's kind of buried in the release, but the SEC does make that clear. So I should say that at least in some cases on these more, I'll call them secondary or more tertiary issues, they're very important, but they're not the main issues of the release. There is at least some attempt to look at past interpretations and potentially indicate that they might move away from them.
Okay, so thanks to both of you. That was wonderfully insightful and informative from both of you, with lots for all of us to think about. So they can hear it on the phone. Let's hear a round of applause for Arthur and Mercer.